Hello, dear Elpish colleagues and friends and other viewers. I am most happy to answer Professor Vasco Pereira da Silva's call for this first issue of our Elpish V Law Review. The circumstance regarding COVID-19 prompted universities to put together a whole new digital system of distant relationship between professors, students, and the academic community that would have taken us a decade to implement in a situation of normality. When these times settle down, we will be left with new tools. And if some of them might be relegated to oblivion, others will certainly remain. Academic relationship will certainly never be the same again. And we must seize these as an opportunity to revise old methods and practices. Many, if not most of them, will show their resilience and recover their previous shape. The greatest example is, I believe, class-based lectures, which only in a small portion will be substituted by distance learning. But publications also face challenges. This is not the place to perform a bilan coûte avantage, as the French say, but we all know how difficult it is to find time to read everything one needs to read and to write everything one needs to write. Not to say of editorial complexities that so many times defy reason. So a V-Law review is a challenge that tries to cope with new times, new needs, and new academic ways. We are all very happy with this initiative and hope to go on perfecting it in the years to come. Today, I will be talking about the following topic: state of emergency and situation of calamity, blurring the legal conditions for fundamental rights restrictions. In Portugal, both the state of emergency and the situation of calamity are situations that must be declared on the basis of a due process, in order to allow the suspension or restriction of some fundamental rights. Both these possibilities have been used in the fight against COVID-19. First, the state of emergency, and after, the situation of calamity. What is troubling is that though they are formally different, very different, they permitted similar courses of action, thus blurring what is a constitutional state of exception and a mere administrative civil protection situation. The state of emergency is governed by formal constitutional legal rules and also a law. The state of emergency is, along with the state of siege, a state of constitutional exception which permits the suspension of fundamental rights other than the rights to life, personal integrity, personal identity, civil capacity, citizenship, non-retroactivity of criminal law, defendants' rights, and freedom of conscience and freedom of religion. These are the rights which cannot be suspended at all. The state of emergency cannot change the distribution of powers between the sovereign bodies of the Republic, the President, government, Parliament, and the courts, nor the governing bodies of the autonomous regions of Azores and Madeira. The state of emergency is bound by constitutional principles such as proportionality and has a time limit of 15 days, though it is possible to renew it. In the COVID context, it was renewed for 2 times in a total period of emergency of 6 weeks. A declaration of the state of emergency is the presidential power, but the government must be consulted and Parliament must authorize the declaration, and not generically, but in all its details. The presidential decree suspended a couple of rights, like the right to strike and the right to resist the abuse of public powers. But other rights related to the freedom of movement, national and international, of assembly and manifestation, rights of workers, property, and religious cult were only allowed to be partially suspended according to what the government saw fit, because the government is legally the executioner of the presidential decree, and in the autonomous regions, also the regional governments and the representatives of the Republic, which are a permanent body appointed by the President. The formula of the presidential decree regarding these rights was something like restrictions can be imposed by public authorities. So the real effects of the presidential decree ended up being determined not in se, but by the government and the health authorities, which, as administrative bodies, are accountable before the government. After all, it was the government and the health authorities who decided, in practical terms, if people could or couldn't go out, if people were allowed to leave their area of residency, etc., as well as the admissible justifications to move around or go out from a potential list which was in the presidential decree. The presidential decree was tailed, after all, as an authorization for administrative restrictions, rather than an act with a force identical to the force of law that would contain all restrictions or suspensions in force. One who read the presidential decree would not gain knowledge of the actual situation of suspension of rights after all. This was a softer option, but arguably one that the Constitution really wanted. Some measures, like sanitary isolation of towns, weren't mentioned but as a general possibility under the presidential decree, very much like another framework existent in Portuguese law, meaning the state of calamity. Indeed, the Civil Protection Basis Law establishes the frame and regime for some situations which justify special administrative measures due to fires, floods, earthquakes, and equivalent situations. The gravest of them is the state of calamity, which is declared by the government alone and allows restrictions such as mobilization of persons for limited time, limitations to circulation or standing of persons and vehicles, sanitary and security isolations, and rationalization of public transportations, communications, water and energy supply, and basic goods. All this, of course, always supported by criminal law regarding disobedience and the use of police powers, as with the measures taken in state of emergency, which are also protected in this fashion. Other laws regarding public health authorize exceptional measures by health authorities in an even more light and airy way, defying the demands of the rule of law. Portugal hadn't had a constitutional state of exception since November 1975, in a moment of democratic consolidation after the revolution that took place on the 24th of April 1974. Though theoretically studied in academia, these were actually uncharted seas that nobody was sure how to navigate. So, due processes were generally followed for the formal declarations, but their contents and day-to-day execution were uncertain and created lots of doubts and conflicts about who was competent to do what. It seems this has been a common problem, not only in European states, but also in the Americas. Take Brazil and the United States as two strong examples. It is still too early to draw strong conclusions, but we can already envisage some lines. First, what modern constitutions intended to keep at a constitutional level, almost exclusively, that is, states of exception, tends to be relinquished to the administration level. Second, this relinquishment not only makes more difficult to easily map the exceptional restrictions on fundamental rights on a given moment, it also makes it dependent on administrative powers using scientific criteria. Third, this makes more difficult the task of control and reviewing bodies. Not only may they lack extensive means of control, They must be willing to impersonate legal obstacles and be accused of impairing the fights that must be fought against or over individual rights if needed. More than saying we weren't prepared for this, it's important to ask what we must do with the experience we're acquiring. I tend to think we need to reinforce administrative law, administrative institutions, and their instances of control. And this is an issue of legal culture to begin with, not exactly of constitutional perfectioning. Because we will have other situations like the one affecting us now, or even a lengthening of the present situation. And we must learn how to not sacrifice freedom on a first impulse. No civil contract survives under cyclical suspensions of rights, especially if, in practical terms, they are decided on a day-to-day basis because of the change of scientific knowledge combined with our fear or claim for zero risk.